Microphone. कुछ है कि नहीं
Your writ petition, fresh writ petition challenging the order passed by the CAT, my lads. Stepping up of the pay, comparing the other officer, which is illegal because both are not from the same cadre. Urgency on the 18th is the contempt petition listed, my lads. 18th March. Executive. Removed, my lad. No caveat. There are two writ petitions, fresh matters. It's covered by the division bench of this honorable court, my lads.
Your Lordship's kind permission, but one come.
Fresh matter.
With your Lordship's kind, one commercial appeal. So that was the interim order was granted on 14/6/2024. Due to the connected appeal has not yet been posted. Thereafter, it was posted and date was fixed on 28/6/2021. Thereafter, one by other way, the appellant has taking time. So now the appeal is very pending appeal. Early ring I have already filed. Yes, served the copy and filed. Urgency, the commercial appeal was dismissed by the commercial court. So as against which this was on the basis of the arbitration court merit. So on the basis of this, you have obtained the interim order. So the entire respondent, respondent. I have already given application, served the application. Early hearing also filed on 25th itself. Yes, ma'am.
Commercial. Two fresh matter arising out of a common order of the Central Administrative Tribunal. Matter pertains to selection. I challenged the notification. During the pendency, selection came to concluded and appointments were made. Thereafter, tribunal has held in my favor, said the notification is bad. Tribunal has held in my favor, said that the notification calling for recruitment is bad. Yet refused to set aside the appointments. I have no grievance with that if ultimately somebody is appointed. My request was, please consider my case for appointment in terms of the recruitment rules. Tribunal, and I quote, in future, there's a possibility that the recruitment rules may be amended. Whenever it is amended, you will not be eligible. Therefore, today I refuse to grant you relief for being considered for selection. In terms of the recruitment rules, I was eligible. Tribunal holds in my favor. Now, the additional list is published. Verification process is completed. Appointment orders are yet to be awaited insofar as additional list. If they are appointed, even if I succeed before your Lordship, there will be no putback. Common order of the tribunal, 2 requests. Main list is appointed. Now, additional list is sought to be operated.
What strength they are operating the additional list? The strength of the tribunal's order or on their own?
On their own, tribunal, if tribunal order is implemented, additional list can't be implemented. I have just filed it. I'll ensure that there are no.
See the objections or remove them after.
It is filed already, If appointments are given, since verification process is. I understand.
File it, see the objection, mention it after lunch. We don't want to envelop with all objections coming to us.
I will ensure. Very well. I'll come back to your Lordships by 2:30. Very well. Very well. Great.
Objections have been complied and notice have been served to respondent.
What is the urgency?
My lord, it has not listed since September, my lord. This is a contractual obligations between the movie producer and the distributor, my lord.
Didn't you mention it earlier? September 24.
Yes, my lord. Then we were waiting to.
What is the urgency today?
My lord, the execution of the The execution of the impugned order should be stayed, ma'am.
Execution file.
No, ma'am.
Matter,
Yes, ma'am.
all objections removed.
Yes, ma'am.
Now, this commercial appeal, I am filing the appeal on 15th November.
Just use the mic.
I am filing this commercial appeal on 15th November. But one application already moved and last month 18th are listed, but this court is not sitting on that day. But no date. No. On the 11/3, an execution is there in the lower court. All objections are removed.
Sir, memo date is it? No date is it?
ಅಲ್ಲ ಅವತ್ತು ಸಿಟ್ಟಿಂಗ್ ಇರಲಿಲ್ಲ 18th ಇತ್ತು 18th ಅಲ್ಲಿ ಸಿಟ್ಟಿಂಗ್ ಇದೆ. Much.
For adjournments, page number 4, page number 5, 16 to 24.
Page
number 5, Your Lordship.
Page number 5.
Serial number 16, Your Lordship. The senior, we are for the respondent number 1. My senior is under the weather. If Your Lordship may grant 2 weeks' time, short accommodation.
I appear for the
serious.
appellate.
Respond number 1, Your Lordship.
This
Yes,
is
Your Lordship.
arbitrator. Second respondent. For the appellant.
Respond number 1 now.
Date. Previous of
26.
the date.
Serial number
26.
19, my lords. Serial number 19, my lords.
Yes.
Nineteen, my lords. 19, my lords. I'm for the appellant. Senior is not keeping well, my lords. Maybe taken up 2 weeks, my lords.
In the other side.
It's a fresh matter, my lords. The other side is not so.
Twenty-four, 3.
24 minutes, serial number 24 minutes. The appellant counsel is hospitalized due to the brain hemorrhage. Brain hemorrhage is hospitalized, one, K.N. Purushottam.
Which number?
Serial number 24 in page 5 minutes.
You are appearing for?
I am appearing for appellant, I am a proxy counsel is hospitalized due to brain hemorrhage. He wants to make an alternative arrangement.
Please, the request for adjournment is made. On behalf of the council of the appellant.
9/6.
Serial number 20.
Lord, serial number 11, page number 4, my lord.
Orders.
Hearing and I.
Orders.
Serial number 26, my lords. Serial number 26, my lords. I appear for respondent number 1, my lords. Same case, my lords. The senior is not keeping well. Other side is informed, my lords. 6, my lords. 26. I appear for respondent number 1, my lords. I appear for appellant. I appear for
Respondents.
appellant. I appear for respondent number 1, my lords.
These are others.
Others are government, my lords.
Others government
Can
and
you read this?
unrepresented respondents and some government. Some government.
Respondent number 1, my lords.
Respondents. Interim order is still today, my lords. Kindly be extended. Grateful.
Serial number 25, Your Honor. I'm for the appellant.
There are some additional documents need to be filed, Your Honor. I pressed for a week time.
My lord, serial number 37, legal aid matter, my lord, I am not keeping well. I have to make a alternative arrangement requesting the committee. 1 week time, only 1 week time. Yeah, please.
My lord. 28-4.
My lord, serial number 31, my lord. I'm for the appellant in this case, my lord. My lord, last time we were instructed to file the paper book.
I appear for the respondent in this
The paper book drafts are ready, my lord. I need to
It's
bind it and get it off done, my lord.
untenable, my lords. On more than 18 occasions, they've sought for admission.
It has been, my lord.
Please.
Well, serial number 17, my lord, I'm for the respondent. I just received the NOC brief today, my lord. Serial number 17 for the respondent in this matter, my lord. I have just received the NOC file today, my lord. I'll be filing my NOC Wakala today for the respondent, my lord. The appellant is here. I've informed the appellant.
I'm for the appellate.
Who is the counsel now appearing?
Vinod, my lord. Previous counsel was Praveen Gowda, my lord.
Who is the counsel now?
Yes, yeah, I'll be the counsel, my lord.
You just come.
Yes.
Just wait. On the list.
Serial number 32, my lord. Serial number 32, my lord, sir. The petitioner counsel informed that, my lord, he is not in station today. May I seek petitioner counsel? Yesterday he called me, my lords. He is not in station today. I seek for next week, my lord, sir. I'm for the respondent number 1, my lords. Petitioner counsel yesterday informed me, my lords, that he is not in station today. We'll come by tomorrow, my lords, sir. Next week, my lords, I seek.
Nine, 6.
Please.
Your lordship, serial number 23, your lordship. Appearing for appellant, your lordship, senior is unwell, kindly 2 weeks time may be granted. Your lordship, serial number 23, your lordship.
For memo, commercial appeal 499. Yes. 499 anyway, sir.
Oh, yes.
File an early hearing. File an early hearing.
Achha.
Okay?
Okay.
File an early, they can just tomorrow, mention it tomorrow after filing.
Achha, yes.
Serial number 1. Vishwas Gowda.
Lords, I filed a memo for withdrawal, my lords.
Serial number 1.
Ready to file it.
Lords, as per my petition and instructions, my lord, to liberty to file another petition.
He will not say. We have an issue on this also. Just make it at the request, the letter counsel. It's, you had instruction to withdraw them.
Yes, ma'am.
Name.
For the respondent statement. Please.
Serial number 2, Shri Partha Sarathi.
Respondent number 2, man.
Yes.
Therefore, respondent number 2, petitioner has filed an application for recalling dismissal for non-prosecution.
Serial number 3.
For the appellant, my lord. Application for recalling the dismiss for non-compliance of a subsection. 1 week time may be granted, my lord. Finally, my lord. All translation copies are ready, my lord.
But what is your case on merits?
Pretty cell matter, man.
Delay of,
You kind. Please, you will recall, you will remove these objections.
Please, ma'am.
The time your applications are allowed, you can't hear the repetition. Feel. Just say that. How much time
1 week, man. Within week, I will comply the office.
did you do it?
Please, ma'am.
Say that.
Seventeen two,
Comply, ma'am.
17-3, sorry, sir, 17. Serial number 4,
That's for appellant, your lordship. That's if a lordship grants a week's time, my lords, I'll file my IA for condonation of delay, your lordship.
Waiting for respondent 6, my lord.
There is 1 day delay, your lordship.
Seventeen 3,
Grateful.
serial number 5, Sri Venkatesh Arbati.
Waiting for appellate in
Aye.
this case, my lord. I have given this PF everything, my lordship, on January 4th.
Nine 6, serial number 6,
Serial number 6, my lords, may I respectfully submit. They have filed this petition, please, my lords, 2024 February. Till today, my lords, having enjoyed the benefit of the interim order, they do not even take steps, my lord, to the respondent number 2. And my lords, my respectful submission is, my lords, one promotion I have been granted, please, my lords, in my entire career at the hands of the learned single judge. That is sought to be challenged, my lords. Office objections are not cured, please, my lords, in 1 year's time.
Lord, it is my appeal. Respondent number 3 is central government, my lord. We've served them papers at the time of
Okay.
filing. We can take notice. My lord, the formal party, yes, my lord. My lords, in fact, this matter was heard, it is admitted also. It is
I
admitted
appear for
also.
the respondent number 2, my lord. I have received copy, my lord, on behalf
Yes,
of the
I've
central
served
government.
all of them.
2 sets have been served on me, my lord.
It is only with, my lords, to frustrate me, please, my lords, that
In fact,
they
my
do
lord,
not cure the defect, my lords, in 1 year.
Ma'am, you appear for 3.
No, my lord, I appear only for 2. I have instructions to appear for 2, my lord.
Who appears for
Union.
3?
my lord, yes.
See, 3 is not served.
Please, my lords, 1 year they don't serve me.
My lord,
Difficulty is only the 3 is the beneficiary.
in fact, my lord, 3, the learned single judge has not passed any order in, my lord, either in favor of respondent number 3 or
Very
against
well.
him.
So you mean to say your appeal is without any merit?
No, my lord.
Then,
My lord, what is,
1 minute.
please,
If we were to agree with you, 3 would not be affected? 3
Lord.
would be affected?
my lord, in fact, my lord, I will serve,
Notice has to be served then?
my lord, on council representing, my lord, respondent
Will
number 3.
not do that. That we need to avoid. For
Yes.
1 year, you did not serve him.
Lord,
And he's right what he's saying.
Lord, 26/7,
I'm retiring, my lord,
2024 was
stop.
the order of, my lord, admission. My lordship had, my lord, admitted the matter. My lord, I had issued notice, my lord, I'll take fresh steps, my lord. In the
They are
week's
not
For
taken
1
steps.
year, it's in the notice stage. We don't
time. Lord, what
understand.
has happened is, my lord, may I make one submission? My lord, what has happened is, my lord, the advertisement for, my lord, the post of
You
assistant.
are ready? We are ready to hear you.
My lord, I'm just bringing it to your lordship's notice that, my lord, what was challenged was, my lord, selection of respondent number 3. But learned single judge has not disturbed that, my lord. Learned single judge has only granted promotion to, my lord, the petitioner, writ petitioner. My lord, insofar as, my lord, recruitment to the post of assistant registrar where respondent number 3 was, my lord, selected, Lord, that has not been disturbed.
So then why are you aggrieved? How are you aggrieved?
My lord, I am aggrieved by grant of promotion, my lord. What had happened is, my lord, what was challenged was recruitment notification. Thereafter, by way of amendment, my lord, a prayer for promotion was included. My lord, what was granted was promotion to the petitioner, my lord. I am aggrieved by that.
Which post promotion to which post?
My lord, promotion to the post of security supervisor,
And which is the post the response?
assistant registrar.
So there is a different, both posts are different?
Different.
So sure.
Yes, my lord, absolutely.
Then what is the difficulty for security superintendent?
My lord, he is not entitled to the reason being.
Why?
My lord, the reason being, my lord, my lord, the petitioner, my lord, joined the services as, my lord, security supervisor.
Okay.
My lord, my lord, as per the rules applicable to him, the maximum promotion that he is entitled to, my lord, is a security officer. My lord, what happened was, my lord, in 2013, the
Now,
recruit.
which security superintendent is a promotion post to security officer?
Yes, my lord, but my lord, pursuant to a 2013 rules, my lord, which specifies that these rules only apply to people who are, my lord, recruited to the within the institute from 2013 and further, my lord, not prior to. My lord, the rules specify. My lord,
When was he appointed?
my lord, he was appointed in 19, my lord,
Lord, I was appointed in the year 1997.
1997. My lord.
Now tell us, 2013, he was in place?
My lord, 2013 he was.
He
in
was
place.
working?
Please, my lord.
Now, will you say so, that because you were appointed in 97, any recruitment rules, any promotion rules which I will bring in will not be applicable?
My lord, what happened was, my lord, those posts, my lord, that the petitioner was seeking, my lord, those posts were abolished. My lord, what happened was assistant registrar's post was included in 2013. And my lord, the post of security superintendent, that was the higher level, my lord, also equivalent to assistant registrar, that was abolished. And my lord, 2013, assistant registrar post came into court, and that specified that these posts will be filled up only through direct recruitment. Therefore, my lord, advertisements were issued. My lord, what learned single judge has done is, my lord, practically, my lord, he has given a post, my lord, identical, equivalent to
The respondent number 3 was appointed direct recruitment.
direct recruitment.
Where is your writ petition? What is the prayer in the writ
My lord, writ
petition?
petition, my lord, shall find at page 38 onwards, my lord, the prayer, your lordship.
Let's see the prayers.
Yes. Page 66, my lord. Prayer number
Prayer
A
and
is
the
to.
writ
One
petition
second, sir,
is
I'm
104.
submitting, sir, 1 second.
104.
Prayer A,
Prayer A quashed the order. This order is the appointment.
this is the recruitment order.
The recruitment, the appointment of
Yes,
the gentleman.
respondent number 3.
Quashed this bearing this for the appointing fifth assistant registrar. Rather, the respondent to promote the petition for the post of assistant security officer.
Prayer B, my lord, was included by way of amendment for promotion.
Equivalent, Rupees 17. Consequential.
And may I make one more submission?
Considering qualification. Service, rather than respondent.
May I make one more submission? My lord,
See, where is the prayer for superintendent, security superintendent?
That's C.
C.
Direct the respondents to promote the petitioner to the rank of assistant registrar security considering his qualifications.
This is a direct
So that's a
recruitment.
direct recruitment post.
Please. And
What is granted is equivalent.
1 minute, please. That's a direct recruitment.
No, that is not.
Where is security superintendent prayer in your petition? What has been granted, he's agreed by that security superintendent.
Please, my lords.
He says, very well, forget, we are not concerning whether it was there or not. We are concerning where is your prayer which has been granted by the single judge.
Lords, please, my lords, BB, please, my lords, was inserted subsequently, please, my lords. Direct the respondents to promote the petitioner as to the post of assistant security officer or its equivalent post with effect.
BD.
Yeah, please, BB, please, my lords, page number 104.
BB.
Yes, my lords.
Where is the security superintendent?
Lords,
So this is
now what happens, my lords, is every 8 years, my lords, they'll have to give one promotion. Every 8 years, as per their own rules. Lords, throughout my career, I don't get a promotion.
Right. That's a different argument. What has been granted by the learner single judge, we are only on that.
Please, my lords.
He says security superintendent, promote him. There is not even a prayer in the
Nomenclature
petition.
may have been different, but the post.
We don't know.
Please, my lord.
See, that's how it creates confusion.
Please.
The direction is security superintendent.
But
Prayer is not there. Whether there is a post, we have to see that. But in any
Post
case,
is there.
there must be a prayer.
Please, my lords. But
1 minute. Any direction to give, promote you as superintendent, first need to be seen is whether you are eligible. If you are eligible, why was not given? If not given, for what reasons? What were your ACRs? To say that there is a direction to promote you, see that Supreme Court has also said, so you will not, the court will not say promote you. Court will say relegate to the DPC. Based on the record, consider his case and do it.
lords, I have a perfect record.
You are saying,
Please,
we have to see from the perspective of the employer.
lords, please.
So two aspects. One, no prayer. Two, at the most, there can be a direction for consideration, nothing more.
That is what has been ordered also.
No, my lord. Para 34, your lordship may see of the impugned order. Page 36.
Lots.
Page 36,
Finally,
para
please,
34.
lots, eventually, please, lots,
34 and 35.
the last prayer. May I only bring it to my lord?
Directed to accord promotion to the superintendent.
Please, not the
And with
last
effect
prayer.
on which date?
Lots from the date,
2005.
please, 2005.
When did you file that petition?
Lots, I filed it, please, my lords.
2019.
2019.
So 14 years back.
No, they
Is
did
it not hit
even
by delay latches?
Look, I quite follow, my lords, but they did not even consider me meals for such long time. I have been representing to them.
You are actually right. We are with you. The court would say, very well. You would say, I have not been considered. Initial consideration should have been in 2005.
Five.
Till 2019, they have not considered.
Considered.
But court will say, very well, we will do one thing. In any case, apparently delay and latches, you would not disagree with us. 2005 cause of action, 2019 it is being filed. You can argue alternatively, please direct them to consider my case at least 3 years preceding the filing of the writ petition in accordance with rules by the DPC. That should be the direction. Provided there is a post of security superintendent. No post, no prayer. We don't know post there or not. Delay latches. These are all things. How would you answer all this?
Can it be called tomorrow, my lords? I'll address.
We'll have it tomorrow. Just
Please.
look into all this.
I'll do that, my lord. But practically, please, my lords, as per their own DPC, my lord, their own rules, every 8 years, my lords, I'll have to be considered for one promotion. They do not even consider me, please, my lords, till the time that I want to retire.
The law is so settled. We are with you. Dr. O.Z. Hussain versus Union. Court has first said, every employee must have at least one promotion in his career. We are with you on that. But for that, there should be an appropriate prayer and appropriate direction to by the court also.
I will only respectfully submit, please, my lords, that prayer C, please, my lords, should cover me to a large extent. Specifically, if it has slipped out, please, my lords, prayer, my lords, D would cover me to some extent.
D.
So, yeah, D. Grant such other reliefs as this honorable court may deem it appropriate, considering the facts and circumstances of the case.
Let's see that.
Yes, please, my lord. So, my lords, when, my lords, the relief has to be molded, please, my lords. The court, my respectful submission is my lords may come to my rescue, because only one promotion they have given me for my entire lifetime. They want, my lords, me to be retiring, please, my lords, the date I assume service. The same cadre they want me to retire.
Now you will also get instructions. Please, you will also get instructions. The gentleman being in place, 2005, according to him, from 2005 till then, when did you join? 97.
97, my lords.
As what did you join?
Lords, I joined, please, my lords, as supervisor, please, my lords.
Security supervisor.
Security supervisor, no change in designation till I retire.
Continued on the
I've
same?
been continued.
When did you retire?
Now this month I'm retiring.
Good.
And last
Month you
year,
are retiring.
last year they filed the
Lord, that
petition.
is
Yes,
not
Lord.
correct.
Today
It
they
is
don't
on
even
record.
cure the office defects,
Lord, that
only
is-
to frustrate
That
me.
is not correct.
That is all
It
my
is,
support.
Yes, 1 minute.
That is not correct, my lord. The records are, my lord, on record before your lordship. My lord, he has been evaluated. What happens is, my lord, every 8 years an employee is evaluated. He has been evaluated and placed in higher scales of play. Only thing is, my lord, there was no channel for promotion for him. Then what happened, my lord? The government of India introduced MACP, my lord, that is Career Progression Scheme. As per that, my lord, he's been placed in higher scales of
You
play.
will get your list of dates. You will also
Very
get
well.
your list of dates. We will have it tomorrow.
Very well. Very well.
So very grateful.
Now, insofar as 3 is concerned, what do you say?
My lord, I have
3, you would not, you want to press it or you want to press this appeal, Quad 3?
my lord, may I?
Quad 3, you have no grievance.
I have no
Your
grievance.
only
my lord.
grievance is against that particular direction of superintendent.
Only that, only. But my lord, if your lordship permits, I will make sure, my lord, the counsel representing the petitioner before the writ petition is present before with instructions, my lord, tomorrow.
Very well, that's up to you.
I'll-
Please, whatever we have heard, both of you, neither you are challenging, neither he is challenging.
Respond number 3.
His promotion appointment having been upheld.
Upheld.
Your only grievance is this direction of senior
Promotion.
superintendent.
Very well. Absolutely.
Can we record your
Yes,
submission?
ma'am. Yes.
That the scope of this appeal would be limited to the direction given in his favor as senior superintendent?
Yes, my lord. In fact,
That's all?
that has been recorded, my lord, by this honorable
You're
court.
only saying that. Just say this.
In the interim order that has been recorded, my lord. The only grievances, my lord, against para
Say
34, my lord, dated 26/7/2024, my lord, while granting interim order of stay, this honorable court has only, my lord, considered grant of stay in respect of para 34 and 35 of the impugned order, which pertains to promotion only.
So that's right. If
Yes.
that is so there is no need for respondent.
Yes,
to this. Just say this, learner counsel for the petitioner states, in view of the order dated 26/7/2024 of this court, comma, as there is a limited challenge in this petition to the extent of direction given by this learner single judge in paragraph 34 and 35. To the extent of granting promotion to the petitioner as security superintendent, comma, notice to respondent number 2 be dispensed with at the risk of the appellant. Noting the said submission, it is ordered accordingly. Re-notify tomorrow, learner counsel for the parties to get their list of dates. Get their list of dates, we'll see it tomorrow. Thank you. Very great.
My lord, it should be respondent number 3, my lord. For 2, I am already there.
Respondent number 3, ma'am. Correct.
Okay.
Great.
Obliged.
Much obliged.
7.
Appealing for the appellant, my lord.
So, 6.
7.
Appealing for the appellant, my lord.
Yes, ma'am.
My lord, there's an office note that it is awaiting notice against respondent number 1.
Just say this in view of the office note. Let's just say that to await the service of notice on respondent number 1, re-notify. See, you have to file the complete arbitral record also.
Please, my lord.
Let the complete arbitral record be filed positively before 1 week before the next date of hearing.
Please, my lord.
2-6.
Much obliged, my lord.
Serial number 8, government advocate, 8.
It's come on PF, my lord.
Yes, ma'am.
8, my lord. Lord, respondent number 1, my lord, is a private party, will take steps, my lord. And so far as R2 is concerned,
Is
planning
there-
authority,
Yes.
R1 will take steps, my lord.
But what is their case on merit?
Lordship's learned single judge, my lord, has caused the notification. Insofar as
But what
relinquishment,
about the earlier writ petition? 15250
my instructions are that, my lord, there is an appeal pending before Supreme Court. I'll ascertain that.
against this order?
Please, no, my lord, similar issue, my lord.
No. This order has been challenged.
No, my lord, not this order. Similar issues, my lord. I'll ascertain that, my lord. I'll ascertain that.
But then, no, what did you do for 155? Have you implemented it?
Yes, my lord.
Then this is something which we are unable to. And the basis for the learner single judge is that.
Lord, it's a state policy, my lord. And my lord, these ring roads, my lord, apparently, my lord, they are in the interest of the public. These ring roads, my lord, are,
And why did you implement that, ma'am?
Lord, I'll ascertain. I have to seek certain instructions,
Say
my lord.
this, notice be issued to respondent number, fresh notice be issued to respondent number 1 and 2.
Lord, 1, we will take steps. 2, we will serve on the council for the planning authority.
Oh, you will serve both, ma'am.
Please.
Additionally, respondent number 2 be served through the standing council. Okay?
Please, my lord, obliged.
2-6. 9, Sri Ranganath Joyce, serial number 9.
Appearing for the respondents, my lord.
Yes.
Matter has been partly heard before. So our submission is the MACP, whatever is.
Who is appearing for the petitioner? Pass over. So was it a date fixed matter? No date now.
Serial number 10. Number 10.
My lord, I am the appellant in this case and the counsel on record also.
The respondent number 1, man.
Yes. And we have moved an application for the delay application, which is a 14 days delay because he is from the Pune and he has not given the instructions. Yes, yeah. I pray with this honorable court to condone this 14 days delay in this.
You appear for whom?
My lord, one more thing. He is insisting for the NOC from Pune and these two councils without obtaining an NOC from us. They have filed an wakalat here. I don't understand how they can file this being an advocate without an NOC applications for that. That is observation is already made there. 1 and 2. Being an advocate, so they should force.
See, if-
No, there is no dispute with any lawyer. It is just that if the code allows, we will appear. If
No,
not,
no.
we will definitely
see,
not
you
appear.
have a responsibility to your colleague
And if
also.
What instruction from our client was that he was not
So
able to obtain it.
you would not give, you're right, you may be right. So do one thing, tell your client, get an NOC from the council. If he gives, then it's fine, then
We have no dispute with any lawyer.
obviously, why should you have? Yes, now, so we do one thing, we just simply re-notify it. Okay?
No, what is the condonation of this one delay today? And let him come and this one, if he instructs and if he comes,
We'll do it on the next date. What is the difficulty? It's
No, no.
only the condonation of delay.
no, today, when I am appearing, let it be I pray for this honorable court to condone this delay of this one on this basis and whatever the instructions, what he is having, let him come and take an NOC.
So for the respondent?
Respondent
What
number
is-
1, man.
What do you say?
My lord, it's delay of 14 days,
It's all right.
Please.
Well, no, nothing much. Say this is an application seeking condonation of 14 days delay in filing the appeal. What are the reasons given by you?
No, he's from Pune. In the arbitration, I only has handled and in
Your condonation of delay, what are the reasons?
reasons is only thing is his illness was in Pune, who is not instructed and has come this one at page number 81.
For the reasons stated in the affidavit in support of. the
Due to
delay,
his illness, he is not.
The delay of 14 days is condoned. Application disposed of. And the learner counsel for the respondent does not seriously, respondent number 1
Respondent number 1, man.
does not seriously contest the application. The delay is condoned. Application disposed of, re-notify the appeal on
7-4,
is the order.
7-4, sir.
Much.
9, my lord.
Sir, 9 is passed over, sir. Serial number 11, she is Amir Pasha. 11,
Appearing for respondent.
Yes. You appear for the respondent,
Yes, my lord.
pass over.
12,
Just say notice.
Junaid.
Sorry, I'm sorry.
I am for the appellant.
Notice that the TCR be requisitioned. Notice on both appeal and delay. Let the TCR be requisitioned on the next date of hearing.
2-6. Serial number 13, Shri Vishwanath Hegde. 13,
I appear for the respondent, my lord.
Appellant, my lord. The appellant number 1 is the company, my lord. It's a bus body building, my lord, company.
Just say you appear for the respondents.
Yes, my lord.
Notice how much you will deposit.
My lord, I have paid out of the claim, my lord, 46 lakhs, my lord, I have paid. My lord, in the execution case, my lord, where attachment of movables was obtained.
You filed an execution after this?
Yes, my lord.
Please, my
How much
lord.
they have paid?
After the last date of hearing on 17th, it was posted. Next day, my lord, I had to face a attachment warrant and had to pay 16 lakhs, my lord, further.
How much is balance?
Lord, according to the decree, my lord, it is 93 lakhs and odd. Out of that, my lord, principal amount is only 47 lakhs 20,000. This is a bus manufacturing unit, my lord. Yes, a bodybuilding manufacturing unit. Lord, it closed its operations because of the COVID-19, my lord, in 2020 March, after the lockdown, my lord. The entire nation, entire world came to a standstill. This there is no willful default. I offer to pay the principal amount, my lord, in installments, even before the commercial court. Lord. There was no, my lord, intention to hold this payment at all. Because of the circumstances beyond the control of the appellant company, my lord, the amounts were fell due. There is no willful default as such, my lord. It cannot be alleged as such, my lord, because on account of the closure of the entire transportation industry, my lord, the unit was closed down.
You don't file your return statement.
My lord, I offer to pay, my lord. I've made a memo, my lord. It is not so, my lord. It is not that I
That's
did
one
not.
thing. Once you offered, who will refuse it when they have filed a claim for
Lord,
recovery?
in this case, my lord, it has no, it is so, my lord. It is refused.
In
my
any
lord.
case, how much is the balance?
It's 46 lakh 7,999.
Still balance?
Yes, my lords.
That's right.
Lord, yes, my lord, that is, my lord, 47 lakhs is the principal amount. 46 lakhs is the interest, my lord, at 30%, my lord. Kindly appreciate, my lord. This is a
So
case.
now we will look into it. Are you only saying only on interest you will be challenging?
Plus, please, my lord.
We will look into it.
Please, my lord.
How much you say? 30%. 30% on what basis?
May I make a humble submission, my lords? If my lords may kindly peruse, the appellant has admitted to the principal amount, my lords. The principal amount is based on the invoices, which is at Exhibit P3 series. Now, when the invoices have already been admitted, my lords, there's a clause which says, my lords, 30% is the interest to be added, assuming they do not pay in the stipulated period of time, my lords. They did not do so. Therefore,
invoice, you raise an invoice, say 30%, 40%, 50%, you say it's binding.
but what happens, my lords? They have admitted to it. If I can understand, my lords, if they have not admitted to it. They have admitted to it.
Obviously, admitted doesn't mean that it should be interest should be 50%.
My lords, it is the meeting of the minds of the parties.
What meeting?
And they have concluded that it should be 30%. Otherwise, the invoices wouldn't have been raised. My lords, if my lords may kindly peruse, the reason is also given. At the page number 23.
Expressly, they have agreed for this.
Yes, my lords.
How?
My lords, if I may bring to my lord's attention to ink page number 6 of the appeal memo, para number 7.
They should be.
Please, my lords.
30%, what is the basis?
My lords, they say the appellants, after service of court notice, entered appearance in the said suit. Though the appellants defendants did not file the written statement, the appellants filed a memo dated 23/2024 proposing to pay the invoice amount of 47,51,208, which means it is the invoice amount that has already been mentioned, my lords.
Okay.
And the invoice is mentioned 30%, my lords. Any invoice, if my lords may kindly peruse, is based on both the parties coming to a conclusion.
What should be the interest? Tell us.
My lords, the parties have already decided that it should be 30%.
We will hear it. You deposit the amount here.
Please,
We will look into it.
Please, my lords, let them deposit the entire amount, man.
Deposit the amount. Invoice. How much is the balance principal amount?
1,20,000.
1,20,000.
Please, my lords.
You will deposit it and you will compute the interest component you have deposited?
No,
No,
my
my
lord.
You have not. So you will deposit interest component at the rate of 18%
Please, may I make a
on the
humble
principal
submission?
amount.
I understand, my lords. I bow down to my lords.
We'll look
But
into it. We'll
what?
look into it.
Please, my lord, at least 20%, my lords.
We will look into it. We have said 18. You will stand by that.
Please,
Just see
my lords.
this. The notice, so and so accept notice for the respondent. We have been informed by the counsel for the appellant an amount of how much you have paid?
46 lakhs, my lord.
Is it a round figure?
Please, my lord.
46 lakhs has been paid to the respondent herein. He concede to the fact that a further amount of rupees
1,20,000 and down.
1,20,000
Please,
is still due and payable to the respondent in terms of the impugned judgment decree.
towards principal.
Towards principal.
Towards the principal amount.
that
No,
is the-
Just say further amount of 1,20,000 is still payable
Towards the
as the
value of the
princi-
invoices, my lord.
as the
It is not-
principal amount based on the invoices
Please.
of which a reference has been made in paragraph so and so of the impugned order. That is in paragraph number 2 of the impugned order. That's right?
Please, my lord.
The details of the invoice?
May I make a humble submission? Madam?
Yes.
Apologies for intervening. The amount pending from the side of the principal, my lords, would be 1,52,208.
51,208.
It's coming as 152.
Say 120, say 1,51,000,
52,208.
52,208.
Please, my lords.
So 152,208. 208 is payable. Good stuff. The appellant shall also, if that be so, the council states the same shall be paid to the respondent number 1 within how much time?
1 week's time.
Within 1 week from today, full stop. The issue now raised by the council for the appellant is the grant of interest at the rate of 30% by the court below. Full stop. Noting the submission made, and on the other hand, learner counsel for the respondent justifying the interest, we deem it appropriate. Learner counsel, the appellant shall deposit the principal amount as determined by the trial court. Would deposit before the court below the interest amount on the principal as granted in favor of the respondent at the rate of, computed at the rate of 18%. 18% on the amount already paid and also on the amount of 1,52,208 to be paid within 1 week. I hope we are clear. Whatever you have paid, you will compute it. Whatever you are paying on 1,52,000, you will compute 18% and deposit it.
Please.
And shall be deposited with the Registrar General of this court within 6 weeks from today. Stop upon such deposit, the amount shall be invested in an interest-bearing FDR of a nationalized bank with periodical renewals. Let the TCR be requisitioned before the next date of TCR we don't require.
May not be required.
In view of the limited issue which falls for consideration in this appeal, appropriate shall be the counsel for the parties shall file their brief note of submissions along with the judgments they want to rely upon.
We will place necessary documents also, my lord.
Within 6, for what?
Lord, because the claim is regarding interest only, my learned friend
Will
wants to.
file only one invoice.
Yes, please,
Or the at least, okay, you file all invoice because you are placing reliance on that only.
please,
Please,
please.
my lords.
Place all the invoice. Rely upon. Additionally, the counsel for the appellant shall file, you have the invoices as exhibited.
Lord, I will obtain and file it.
Learner counsel for the appellant shall only file on record the invoices which have been raised by the respondent from time to time, of which a reference is given in paragraph 2 of the impugned judgment decree dated so and so within 6 weeks. Okay.
If my lords may grant me liberty, my lords, even I shall do so. If my learned friend could not obtain, I have anyway the invoices.
Between both of you.
Please.
You want him or you?
If I don't have the certified copies,
Right,
if
he's
my
right.
learned friend has certified copies,
He is right. Just say respondent, not say appellant, say respondent. There is only one respondent, no?
Only one respondent, my lords.
Okay, list the appeal on.
9-6.
Please, my lords. Much obliged.
Lord, formal, Lord, order, Lord, regarding delay condonation may be passed.
Delay of 64 days is condoned for the reasons stated in the affidavit.
Much obliged.
14. Amit Hegde.
My lord, the appeal pertains to enhancement of compensation. My lord, already the honorable court has issued notice in other similar type of matters. I'm
What is the
placing-
case?
My lord, the case is that the enhancement of compensation has to be
Is the
done.
same village?
Yes, my lord. Yes, my lord. Same village, same award, same notification. It's
Close the
posted
order.
before this honorable court on 25/3, man.
Close the order.
I filed.
So what does he say, man? Oh, there's a memo. What does he say? Did we issue notice? Just say that learner counsel for the appellant states on identical appeals.
Please, ma'am.
Notice has been issued for 25/3.
Please, ma'am.
Accordingly, issue notice to the respondents returnable on 25/3.
Much obliged.
Serial number 15.
In serial number 15, I appear for the appellant, your lordship. I have deposited the entire
Yeah.
award on amount in compliance of the, but the amount was,
Can we hear you?
yes, your lordship,
Yeah, pass over.
My lord,
We'll hear you.
PCR has to come.
no, your lordship, I am not ready to argue the main appeal, but the amount has been deposited, your lordship. 23 lakhs,
You are for the
4,877.
respondent?
Respondent, my lord.
Okay, just say admit. Trial court record, yeah, papers will be filed within 6 weeks. Yeah, within 8 weeks, list on.
16-6,
Please.
Much obliged.
16 urgent,
And the amount deposited, no? Okay. Yes.
16 urgent, 17. Srimati
appellant,
Manisha
please.
Kapoor.
That's matter arising out of a dissolution of a firm. The firm has been dissolved. It was a firm at will, partnership firm at will. This section 9 was filed, my lords, because we wanted a receiver appointed. We were not given access to the company and we had information that there were assets there.
Section 9, ma'am, you have to work out. We don't know. There is a history also says possibly there were earlier proceedings also before the arbitrator.
My lords, there is a separate section 9. That apart, my lords, I must submit today that there is an arbitrator already appointed.
Oh, already appointed. We'll
Already
work it out.
appointed,
It's
my lords.
commenced, my lord.
My only submission is this, my lords, the only ground on which the impugned order I'm challenging.
Ma'am, once arbitrator, you have section 17.
Certainly, my lords. My submission is this, that let me have the liberty to raise all these grounds and let me not be bound by the learned trial court's
Who is
order.
preventing you?
My lords, learned trial court's order should not act as a precedent. That's my only concern, my lords. That
Pardon?
today they should not say it's unchallenged, that there was nothing there, and they take the ground that it has already been decided.
Lord, I,
According to the council, this order of dismissal must not come if he files a application before
Please.
arbitrator.
please, ma'am. Please,
That is right, I suppose.
yeah, please, ma'am.
So we take it, we'll record your concurrence.
Yes, ma'am. Yes,
And she will withdraw it.
yes, ma'am.
And we are recording this. An arbitrator has been appointed by the parties and she intends to withdraw you intends to withdraw this to file appropriate application before the learned arbitrator for his
My
consideration.
lords, may I just make one
Pardon,
submission?
Listen to us. Any observation must, and he should decide it without being influenced by section 9 order.
Please, ma'am.
That's all.
Please, ma'am.
My lords, I have no objection. My only concern is I have not been able to get instructions on the withdrawal from my client. And my lords have it even next week. He's traveling. I'm not
Let's
able to
be
get
very
it on-
clear. We are very clear.
Absolutely, my
We
lords.
will not allow one proceedings here, one proceedings here.
No,
Let's
my
be
lords,
clear.
my only submission is I don't want to make a submission without informing
No,
the
we
client
will-
on withdrawal. That's the only submission. If my lords are disposing with liberty, my lords, I have no
We
objection.
will not. We will allow you
Withdraw-
to withdraw it.
My lords, I have no-
Take instruction, we'll pass over.
that, my lords, he's not available. I've already tried yesterday, my lords. He's traveling. Otherwise, I would have already made that submission saying I'm withdrawing. I'm not able to reach him. That's
We
the
will
only
not
reason.
only say, we will not only allow you to withdraw it, to enable him, we will record his consent that they are liberty without being influenced. So we'll have it tomorrow. Get your instructions.
May I request for Monday, my lords? I believe he's
No,
traveling.
Monday.
His phone is off.
Small
I'm not
issue, we
able to
don't
reach him.
understand, man. This is just matter of do one thing, give a try now. We'll have it after lunch. Pass over.
Lords, I've already tried. That's the only reason, maybe.
Try another, what is there?
Tomorrow, my lords, then I'll try and reach him.
Okay, tomorrow. At the request of counsel for the appellant to take instructions, re-notify.
My lord, Wednesday, my lord, tomorrow, difficulty, Wednesday, please.
No, then we will have it after lunch.
After lunch, my lord, if not,
Can't add on, the list.
after lunch, my lord, but tomorrow,
After
decline
lunch.
difficulty.
Take instructions.
Try my lord. First. 18.
I may request a week's time.
For what?
The paper book is also not complete. Certain records have to be brought on.
One submission. Sessions court, LCR has to be called, but it is all there in Xerox copies. Hence, it may be called. In the meantime, we will address arguments next week, finally. It may be disposed of on the same day. LCR may be called from Sessions Court.
Just say why don't you file your paper books?
No, paper book I have filed, but Xerox copies, they will not give certified copies. That is
Let
the
the,
rule.
let the TCR be requisitioned before the next date of hearing.
Sessions Court.
Just give it in June, ma'am.
16-6.
I may request 17th.
Pardon?
I may request the 17th.
Just give it in April, give it in April.
21-4.
Obliged.
19 adjourned. 20. Prasanna Kumar. Here number
This
20.
appeal arises out of a common judgment on two arbitration proceedings.
Have you invoked arbitration? What has he done, the Learned Trial Court?
Yeah, he's under section 9, he's given the injunction order and
So you will invoke arbitration, ma'am.
I
And
think,
he's right. He says so this issue need to be decided by the arbitrator.
I'll
Who
get
who
instruction.
appears for the respondent.
First time, my lord. I think, I'm not very sure on that instruction. I could not seek, my lord. Maybe 3:30 and 3:22 tag law, and that hearing tomorrow, day after tomorrow, I'll have the instruction and this could be disposed of if the arbitration proceedings have already been initiated.
Have they been initiated?
I do not have the.
We'll pass over, take instructions.
Please,
We just pass over.
please.
Both the matter, this is a common appeal against two orders.
Please,
no?
there is one more, commercial appeal 328 of 2024.
Where is it listed?
It's not listed. This is the first one.
Okay, take instructions in this.
21. So Virupakshaya. 21.
Hearing for the appellant.
Yes.
The matter pertains to land acquisition notes. The land owned by the appellant notes was acquired by the respondent authorities, my lord. And compensation was awarded, my lords. We preferred, my lords, an application before the deputy commissioner, my lords. The deputy commissioner, my lords, enhanced the compensation, my lords.
How would you come over this?
My lords, with regard to the delay, my lords,
See, it's apparent he's right. He doesn't have even, he can't even look at it. 21 and 23 is the appeal, 34.
so only
You may have, for the purpose of section 5, you may have grounds, but not for the purpose of 34(3).
Lords, in the appeal, my lords, under section 34, we had filed an application, my lords, under section 5, my lords. That has been delay, my lords, of 2 years, my lord.
Difficult.
Lords, in fact,
He's right. He can't even condone. Now, neither we. Okay. Just say this, the challenge in this appeal is to an order dated 31st January 2024, passed by 6 additional districts and session judge Tumakuru, whereby the learned district sessions judge has dismissed the challenge made by the appellant herein to an award dated 18/8/2022, passed by the respondent number 2, respondent number passed by the learned arbitrator, say that, by stating in paragraph in paragraph 8 and 9 as under. Full stop. Consequently, the learned sessions judge has dismissed the petition filed under section 34 as not maintainable, oblique barred by limitation. As barred by limitation, though we are of the view that 34, in view of the fact that application under section 5 was rejected, application for condonation of delay was rejected, the petition under section 34 was not maintainable. In any case, we agree, except the fact that the section 5 application, section 5 of the Limitation Act is not maintainable, was not maintainable, comma, on facts as noted from the impugned order. The award dated 18/8/2021 has been challenged by the appellant only on by filing a petition on, what is the date?
Let's say 8/8/2023.
Huh?
8/8/2023.
8/8/2023, much beyond the permissible limit of 3 months and 30 days. So in that regard, we agree with the final conclusion drawn by the sessions judge in rejecting the condonation of delay and consequently the petition under section 34 of the Arbitration and Conciliation Act. The appeal is dismissed, being without merit.
Shri Kashyap Naik.
Therefore, the appeal against the section 9 application being allowed, my lords. Arbitrator has been appointed, constituted.
So you will withdraw it. You will withdraw it.
No, my lords, I need it to be set aside.
Why?
It has been allowed against me. An order of deposit has been passed. I can show your honors that prima facie errors apparent on into the face of the record.
So what do you want?
I want the order set aside with liberty to them to approach the arbitrator with the same relief if they deem fit. I will show your honors the impugned order. My lords will see page 35.
We can only think, who is the counsel appearing there?
May
You are appearing for the respondent?
please, my lord, may I request that a copy of the appeal be served, my lord? I will take notice, my lord.
What notice? Arbitrator in place, we have been informed.
Please, my lord, the pleadings are complete, in fact, my lord.
Even in the main claim petition.
Yes,
Please, my lord.
issues have been
Now,
framed.
he wants to withdraw this appeal.
No, my lords, I
1
want-
minute. Very well. We are putting it to him that he should withdraw the appeal.
Please, my lord.
But he says the impugned order is need to be set aside to enable him to file an appropriate application seeking a similar interim relief before the arbitrator.
My lord, I am the successful person in the section 9 application.
You're right. So 1 minute. So we can say this. We can say this. So you have an interim order in your favor. We can give liberty to the appellant herein to file any appropriate application for any appropriate pair, including for vacation of this stay or for modification of the order which has been passed for the consideration of the arbitrator. We can say this.
Grateful, my lord.
If I can make one submission.
That's all.
I would be a little uncomfortable with that, my lords, because practical reasons are the arbitrator is charging.
And we will dismiss this.
No, not at all.
So better would be, we are leaving that window to you. Seek vacation, modification, or anything which you want of that order before the arbitrator.
My only concern, my lords, is that I will be increasing the number of hearings before the arbitrator who is.
That's for you
I
to take
understand.
it.
Very well, my lords. I will take instructions, my lords. Matter may be held
Take
tomorrow.
it, pass over.
Very good.
23, K.V. Narasimhan.
Appearing for appellant, your lordship. Senior is unwell, kindly 2 weeks time may be granted.
For what?
Senior is unwell, your lordship.
We have been informed that the council is unwell, adjourned to.
24-3,
Pledged, your lordship.
24 adjourned. Serial number 20.
I'm sorry, my lords, for the interruption. Item number 24, my lords, I beg to appear for the respondent number 4, my lords. I have received instruction
Lordships may permit me to, my lords, enter appearance for respondent number 4 in this matter. Very short question, my lords. Public road, my lords, construction is being carried out in a public road. I had filed a complaint. This is the 4th round of litigation, my lords, before this honorable court.
See, there was a mention made in this.
Very well. My only
The appellant, he is saying unwell.
Very well.
You appear for R4.
R4, my lords. I have received instructions only yesterday.
Just say that, what is the good name?
Ajay Kattu.
Ajay? Mr. So-and-so appears for the respondent number 4. Okay. Just we mark the appearance of so-and-so for respondent number 4.
May I request, my lord, subject to my lord's convenience, for this matter to be taken up during the next week, my lord.
We have already given a date. We will not change the date. What is the date, ma'am?
9/6.
9/6. If you want an early hearing, you have to file an early hearing.
Very, I'm so very.
25, serial number 25. Ajit. Appearing for the
Is
state,
this-
my lord.
Respond number 8 in this case.
26. Who appears for the appellant?
I represent respond number 8 in this case, my lord.
Pardon?
I represent respond number 8 in this case. I'm the actual owner of the property at present minutes.
But only one respondent has filed this appeal.
Please. Narayan Rao.
No. See, if you see the impugned order, there were quite a few respondents from 5 onwards.
Over there also the petitioner is Narayan Rao, my lord.
No, 1
No,
minute.
the petitioner's appeal.
Petitioner is
Why
before.
do we have this? Ma'am, just check up this. It's only this, no, she is here. ये देखो ये है ना?
Is somebody different. Yes, sir.
25. Okay. What is the ground of dismissal?
May I submit? The petitioner, the appellant here is claiming server number 63 and 82 of Bommenalli village, Bangalore East Taluk, madam. My lords, to be the Inam lands. My lords.
Notice also hasn't gone, my lord. Notice also hasn't gone. I am
Have the caveat. Yes, ma'am. Yes, ma'am.
Let us speak, let us.
Please. Please.
Yes, please.
26, Arjun. 27.
Lords, I appear for the appellant minutes. My lords, Karnataka Power Corporation, my lords, had employed one Mr. Baswaraj as the assistant executive engineer. Now, my lords, he seeks a deputation to go to BBMP. My lords, he goes to BBMP. Still in BBMP. My lords, I'll explain. My lord, the difficulty that I have is that my organization has positions in very remote places. I run power plants in very remote places. I appoint engineers against a cadre. Once I appoint a technical person, my lords, I cannot then appoint anybody else to his space. Nobody will want to take a My lords, we've called him back. We've called him back. My lords, kindly see, my lords, my lords, kindly see page 185. Kindly see page, my lords, BBMP also writes a letter saying, take him back. BBMP writes a letter saying, take him back. Then thereafter, my lords, Annexure F at page 79, 1 year later, they write one more letter saying we are continuing him in service. No, my lords, I'm the parent cadre. I have written. Yes, ma'am. Yes, yes, ma'am.
We are unable to now continue.
We have written so. We've written so.
You have written to have the we are very sorry. You are not powerless. Indeed, you are not actually powerless. This is very surprising. But a principal employer who wants an employee to be back.
Yes.
You are not doing it.
I'll tell my lords what the difficulty is. Just one, I'll just point out, my lords, what the difficulty is. What has happened is that under the allocation of business rules, my lord, the energy department would be the parental cadre. Here, my lords, the urban development department, which has nothing to do with me, has consented on my behalf.
That consent be given by the urban department.
My lords, the difficulty is it cannot be under the rules of, but my lords, the difficulty is that learned single judge has completely precluded all my opportunities. The difficulty, my lords. Yes, my lords. My lords, the difficulty is that he does not take into consideration the fact that BBMP had already relieved him before extending it. That is why I just want my lords to look at 2 annexures. After that, my lords, I will not say anything more. Just look at only, my lords, for a minute, please look at, my lords, page 185, which is annexure R12, which I had filed, my lords. Page 186, my lords, is the relevant portion.
He only said charge sheet, but he's concerned he's not unauthorized.
No, that I'll explain. I'll come to that in a minute. Just 1 minute, please look at 186. 1 minute, I'll come to that, my lords. My lords, the paragraph 8, my lords, goes against me. I'll explain. There's a confusion. What has happened? I'll explain. Page 186. My lords have page 186, my lords. My lords may see page 186. It's a letter written by Undersecretary to Urban Development saying that his service be transferred back to parental cadre. Now, my lords, may kindly see page 79, relevant portion at page 80.
Appearing for respondent 3, my lord. BBMP.
My lords, the employee, my lords, is not appearing in the matter. We tried to serve the counsel for he said, my lords, he's been served. This Baswaraju has been served, but my lords, he's not appearing. My lords, page 80, my lords, kindly see page 80, my lords. My lords, see the date on the letter, my lords. My lords, the difficulty is this, my lords. The problem is that this order, my lords, annexure F, is passed in complete oversight of the order at annexure R12, which is again an order written by the same department. The same department relieves him. Then the same department again extends him. After extending him for 2 years, again they extend him for a further period of 2 years. Again, they're extending it. The difficulty that I'm having is, my lord, I have written several letters to the government. I've written several letters every year. My lords, effectively, my lords, the difficulty here is this, my lord. Because of a powerful employee who has some connections in Vidhan Sauda, I have to file a writ petition against my own government. I fully understand what, my lord. My lords, it is very embarrassing, my lords. It is really embarrassing, my lords. The difficulty is this, my lord. My only submission, only thing what I'll place before my lords is when they have only relieved in 2019. Once they have relieved in 2019, how is it possible to retrospectively get him back on the cadre? Yes, my lord. Yeah, my lord, on the charge sheet, my lords.
basis of their letter, he is continuing on deputation. He say you can't say he is unauthorizedly absent. Hence, set aside. Regarding his future continuance on deputation, it's between you and them to work it out. What is the issue now remaining?
My lords, I'll explain. My lords, if my lords were to accept my contention that without my consent, that is an issue, my lords. My lords, I have specifically the charge memo. Charge.
So, not unauthorized at the relevant point of time.
No, but he was unauthorized from 2019 to 2020. That aspect also we looked into.
Marvelous. That he goes on deputation.
Yes, my lords.
But he was unauthorized particular period, again that his continuance has been regularized on deputation. That's what happened.
My lords, the difficulty is this. Then if my lords were to rule on it, then my lords are ruling that the extension by the BBMP without my consent is valid. My lords, if my lords were to say that the charge sheet is bad, effectively it means that. My lords, yes, my lords. Yes, several letters, all letters are produced along with the. Yes, my lords, we did. My lords may see my statement of objections, my lord. Kindly see my statement of objections at paragraph. Yes, my lords, I fully, my lords, paragraph, my lord, I see paragraph. My lords may kindly see page 43 for a minute. I had filed a memo because there was an irregularity in the charge sheet. That is the problem. That is the specific contention which he had raised. Page 43, my lords may kindly see for a minute. Page 43 minutes, just 1 minute. My lords, in page 43, 5.2, my lords, is the ground raised. My lords, see. The impugned charge memo dated so-and-so is unsustainable as it is contrary to Rule 11.3 of the KPCL rules. Rule 11.3 provides as under procedure for imposing major penalties. Where it is proposed to hold an inquiry against the employee under these rules, disciplinary authority shall draw up or cause to be drawn up substance of imputation into definite and distinct articles of charge, statement of imputations of misconduct or misbehavior, statement of all relevant facts, any admission, confession made by employees, list of documents and list of witnesses, articles of process. This, my lords, was not followed. Kindly now, my lords, see page 133 in my statement of objections, what I say in respect of that. My lords, at page 136, my lords. My lords, he's not, my lords, he's not, he's appearing for the BBMP. He's, the Baswaraj, the employee is not there. Employee is not represented. My lords, he's been served. BBMP. Yes.
My lord, my senior out of station, my lord.
My lords have paragraph 20. 2 years. 2 years. That's it. My lords, he's now, my lords, in his 8th year. My lords, the difficulty is every single employee is doing the same thing now.
When will the senior come?
My lord, tomorrow.
May I request for permission to serve the counsel for the petitioner in the lower court? Served. my lords. Yes, it's been served.
Tenth March,
Bless my lords.
10-3, serial number 28. So,
Paper appellant, lordship may kindly see, there are certain documents applied. Still, I want to some documents required by this case. Therefore, lordship may kindly grant 3 weeks or 2 weeks. That's. No, I'll argue the matter. I am the appellant.
KSRTC.
No. KSRTC is not working. Sorry. KSRTC is rare. I am the workman. Lordship, no, Lordship may kindly say, grant 2 weeks time, last.
We have to be satisfied.
I'll satisfy the.
Yes. Tell us.
No, that requirement of trial court documents, I have led evidence. That inquiry conducted by the management evidence, chief examination chief and cross examination and MW2. But they have examined whether those documents is admitted fact is there. No, reference is there. Your lordship may kindly see, reference is here by kindly see annexure F 64 page. There is a reference. Whether first party is justified in raising the dispute on behalf of the workman. Reference soon after 2005, I have retired after 2004. Soon after 25 or 2005, I raised. Cause of action is the 2004-5. Appeal, appellate authority, I have filed an appeal, appellate authority before the appeal against the order of the disciplinary authority. Impose punishment 6 months punishment, minor punishment. 6 months reduce the pay. Yes. No.
In
90, I filed an appeal before the appellate authority. That appeal is not disposed. Therefore, I am waiting for 2004 till I am superannuated. No, therefore, lordship may kindly see the cross-examination of MW1. She said, lordship may page 53 cross-examination. 53. On previous occasion, lordship may I read? On previous occasion, I have served in BMTC at Mysore, Hubli, Sirsi, Mangalore, and now from September 2017, I am working in Central Division KSRTC as establishment superintendent. The establishment section and default section are different section. The supervisor in establishment section and the default section are different officials, but the superintendent is the same official or both section. The files are moving through me in establishment section, and whether administrative officer is not in office in default section, the files are moving through me. The keys of record section are to be given to the concerned case worker to search the file in the record room. With permission of administrative officer, I have go to record section to search file. I do not know when past history sheet was generated. Soon after passing punishment order, the same will be entered in the service register of the concerned workman and also to personal file of the workman. It is not true to suggest that the service register goes to a category. After retirement, service register and the personal file will go into the C category. Till retirement, the service register and personal file is retained in the establishment section. Yes. The purpose of it is not destroyed records. Still, I am retired from service. They did not, they did not file any records before the trial court, except myself is filed and marked those documents. Therefore, the management has produced a witness before the trial court and examined the filed affidavit in chief I have cross-examination elaborately, in the learner single, and also in favor of the award in favor of me, and the learner single judge is not appreciating those cross-examination, and also the others portion of the award. Therefore, it is a, and also Lordship may kindly see
Happened in the award.
award in favor of me. Now, Lordship may kindly see 64 page. 64, page number 64. It is elaborately, they are appreciating the 64 award, Annex F. There is no, as per the Supreme Court says in a Ranbir Singh case, the delay did not apply. I read this. Read. Raghuveer Singh. Lordship may kindly see. Page 13 of the award. The workman examined himself of WW1 and reiterated the contention taken in the claim statement. He has further stated in his evidence that the law of limitation.
Well, the one increment was postponed for a period of 6 months, my lord. The cause of action would arise for him, my lord. For 6, my lord, it was for 6 months, my lord. Ensuing increment, my lord. The one, yes, my lord. Yes. Well, the order of punishment is that annexure A, my lord.
Yes, sir.
How much when? Did you raise the reference?
2005-6.
2011.
Not 11. It is remanded the back again. Because 2000, soon after 2005, there is an award. Right. 19 years. 19 years. Now, Lordship, Raghuveer case is there. The reference is 10(1)(c). Any time is there. Therefore, I can. My point is, Lordship, one point. I have filed soon after immediately the punishment order received by the workman and filed an appeal before the appellate authority. The appellate authority duty to dispose the appeal. Otherwise, what it happens, sir? If you not disposed, suppose, then the appeal is retained till there in the my appeal. Therefore, Lordship may kindly say, the workman, if you suppose or immediately soon after rise 2011, 9 or 10, 11, 1991, 92, they have again they have dismissed by me because why you raised it with 6 months to 1 year, the question arise. The disciplinary authority did not listen all these things. Therefore, a workman, why soon after retired 2004, he filed a reference before the adjudicate before the reference under section 12 of the Industrial Dispute Act. Yes, correct. That's correct. That's correct. The duty of the disciplinary authority or appellate authority has disposed the case. Otherwise, I did not wait otherwise. It is only hardly about 20,000 rupees. That's all. My 6 months. Yes, that's the principle of law. Because there is no inquiry was conducted. It is a minor penalty. Regulation 22 says, C&D regulation, I leave it to the. Then that is. Thereafter, the Raghuveer case, Lordship may kindly see, it is that entire go through the Raghuveer case, the Justice Gopal Gaud and Justice Bhanumati has rendered that judgment. There is no delay arises under section 10(1)(c) because it is any time can be raised in the dispute. Therefore, it is only 20,000 also is there.
Yes.
No, they have not challenged.
In the writ petition. In my writ petition, it's my writ petition, my lord. The first prayer is, yes, ma'am.
And decided it,
Yes, my lord.
decided it.
Yes, ma'am.
So you did not challenge that.
My lord, I only had to challenge, my lord, along with the, that's the law, my lord. Yes, ma'am. Yes, my lord. That's my first prayer. My lord, the first prayer, my lord, was challenged in the reference order. Yes, my lord. My lord, because, no, I challenged it for this reason, my lord. If your lordship could see, my lord, the implementation of the order is under question, my lord. What is under question is kindly see Annexure A, my lord. Annexure A is not the order of punishment. To that extent I challenged. Because there is a reference is already there, my lord, in my favor. Because the reference order is whether is justified in raising the dispute after lapse of 19 years. My lord, after lapse of 19 years, he comes up with a plea because the law laid down by the apex court in Prabhakar case, that is after Raghuveer Singh case, my lord, by reiterating, my lord, and by distinguishing the law laid down in Raghuveer Singh case, my lord. My lord, reference order is Annexure B, my lord. Annexure B, page 40 is the translated portion, my lord. Whether the applicant is justified in raising the dispute after lapse of 90. My lord, the Labour Court refers to Raghuveer Singh case, my lord, and comes to the conclusion that the delay, my lord, would not matter because of the fact that, my lord, the evidence is it's not a case of either there was no loss or unavailable of evidence due to delay. It's not so, my lord. I have led evidence and I've said that after 5 years, in terms of my circular, my lord, I destroy the records after 5 years. I do not retain. My lord, that is page number 75, my lord. In page number 75. That is para 16, my lord. Para 16. Learned counsel for the first party is also relied on the decision of so-and-so. Their lordships have held that regulation 22 was not followed and allowed the repetition in the said case with regard to hearing on inquiry by the petitioner. The allegations made against the first party workman and the punishments were issued to him on the charge without holding an inquiry. In this said case, law recognizes for issuance of charge sheet after framing the charges. It mandates on the part of the second party to hold inquiry against the erring officials or whether he has committed misconduct or not. Without the inquiry report, the punishments were passed behind his back, which hits the principles of natural justice. In the present case, no choice to conduct the defense by the official who committed misconduct as alleged in the charge sheet. Therefore, it cannot be held that there is delay in raising the dispute as he was unaware of the punishment order. In the case between, so this is what the court says, my lord, that he was unaware of the punishment order. But he was unaware of the punishment order. But as per Annexure A, my lord, his pay was reduced from 1050, my lord, to 1030, my lord. It's a 1020, sorry, 30 rupees, my lord, was reduced. And that he has suffered, my lord, from 1991. My lord, charge sheet was issued. And his reply was considered. My lord,
Yes.
he has not filed an appeal. If
No.
your lordship could see.
Yes, filed his appeal.
My lord, if your lordship could see.
Lordship may kindly see.
Page number, my lord, the last page of the award, my lord. The documents that is produced is W1 is the punishment order. W2 is the copy of the reply to the articles of charge.
No.
Except these two, my lord, he has not filed an appeal. My lord, to show that he had filed an appeal, it was for him to prove, my lord. He has not filed, my lord, the appeal.
This is not one case, Lordship. There are 8 case references. Single reference was referred by the government. Therefore, I filed one single cases, entire mark those documents, appellate authority order. Therefore, this case is not referred in the appeal award. Lordship may kindly,
The
therefore,
punishment order,
I produce that.
1080, my lord, was reduced to 1050 for a period of, that is what he would have got, my lord, was postponed by 6 months. 30 rupees was postponed by 6 months. That he challenges, my lord, after lapse of 19 years, my lord. And in Prabhakar case, my lord, I maybe just, my lord, I've stated so in my petition, my lord. Lord, maybe just passed over, my lord, I'll get it, Lord, I've asked my colleague to get it, my lord, anytime they'll get it, my lord. Yes. And Raghuveer Singh case, my lord, has been, my lord, discussed in Prabhakar case. My lord? Yes, my lord. Yes. my lord. Sorry, my lord, yes, I'll get it, my lord, in 5 minutes.
Case number 29.
Much obliged.
Appear for the first respondent, my lord. I appear for the first respondent, Union of India, my lord. I'm sorry. I'm sorry, I'm not informed.
Since the respondents, Bhimappa, Dattappa.
Yes, my lord.
Var respondent 4 to 9. Yes. Who appears for 4 to 9.
Applicant has been dismissed, your lord. 4 to 9 is dismissed.
4 to 9 is dismissed.
Petition is dismissed.
Who appears for the appellants, the petitioners?
One Mr. Satyananda Murthy, my lord.
Yeah.
Nityananda Murthy.
Case number 30. 30, Shri Prakash Shetty.
Lords, I appear for the petitioner, but may I seek some more time, my lord? I am not ready fully.
Why, Mr. Shetty, what is there in this? Now, what has been said is this only. Mr. Shetty,
Please, my lords.
now there is a new transfer policy in place. you see the directions of the tribunal.
Yes. My lord, the order of the tribunal has already been implemented. My lord, only they have the
You appear
the
for-
order of transfer has been quashed by the tribunal. My lord, that we have challenged it. Now, my lord, during the pendency of the writ petition, my lord, they were already permitted to report it to duty at the ESI hospital at Rajajinagar. They have been working there. My lord,
So
even
what
though there is
remains,
an
what remains in this? Is it a fact?
They have been.
They have been now asked to report.
They've been asked to report.
You are working there.
they are working, my lord, they.
Then what remains in this, Mr. Shetty?
But all my lord, whether the order of the tribunal, because there was some delay they have. May I request your lordship, may have it after 1 week to, I'll check it up and come back to your lordship, my lord.
Yeah, I see, and mind it, the final direction was that in terms of the new policy,
Yes.
and you act in accordance with the new policy of 26/2022, and also
Yes.
to reconsider transfer of the applicant for new transfer policy and to issue a reasonable and speaking order as per new policy.
But I think the order, the order of transfer was passed before the new policy.
For new policy, na?
Before new policy. I
But in
think
any
new
case, now they have joined. Now you are not precluded to transfer them. You are the employer. You can pass a fresh order if you want. But in terms of new policy,
New policy only. That is true, my lords.
you pass it.
But whether the
What whether? Just say that at the request of Mr. Shetty, re-notify Monday.
Lords, you have it next week. I'll come back to you, my lord. I think.
Yeah, we are
if the-
fixing it next Monday
N3, sir.
uh,
in both the matters.
May I request your lordship, have it on 11th, my lord, instead of 11th, 10th, instead of 10th, 11th, your lordship may have it. my lord.
Okay.
Please, my lords, I will come back to you. I think that.
And
I'll
mind
put
it, you have now allowed them what remains in this.
Yeah, that is true, my lord, your lordship is right. I'll check.
Just say 11th.
31, Venkatesh.
I beg to appeal for the response.
For the appellant in this case, my lord, in this case, we were directed to file a paper books, my lord. Last time on 9/1, at the our request, the respondent were able to provide us documents. I'm very thankful for them to give.
To give us the
but
paper book, we'll take it
My
on
lord,
record.
the paper book I have some problems, my lord. I got 100 documents were available, my lord.
We don't require documents. Let's assume, make your case. What is your case?
My lord, it is ready, my lord. I just need
No,
to
no,
buy it
well,
and I have to submit it. The paper book drafting is completed, my lord. We have typed it, my
One
lord.
minute.
Yes, my lord.
What is your case? What is your case? Tell us.
We have challenged the sole arbitrators award, my lord, in this case. It has been, but my lord, we have taken for paper books and we couldn't do it in time. I apologize for that, my lord.
Arbitration. How much he has awarded?
I'll just take mine.
Make submission.
How much he has awarded the arbitrator?
Well, it is not the award. It says suit for actually a specific performance of the agreement.
Oh.
But 166 acres of coffee plantation was agreed to be sold for 4.25 crores by the appellant to the respondent. He has paid 3.75 crores. There is a condition that he has to produce all the original documents which were in the bank. He did not produce it. And later there was a delay on his part. And we said that, no, let us go to the arbitration. That is how arbitration clause was invoked.
What does the arbitrator say?
Arbitrator says that I am entitled for the specific performance of the agreement and to pay the balance amount along with some 10% interest as on the date. We have deposited the entire amount, balance amount.
He appears for appellant?
Respondent, I appear for respondent. I am sorry.
When will you file the paper book?
My lord, another 3 weeks, my lord, it will be done.
How much?
My lord, it's, another 2 documents, my lord, and,
After how many times you were given opportunity?
My lord, sir, the order for paper book was passed on,
3 months.
prior
last
to
3
that,
months.
yes, we have got many occasion, my lord, but paper book was passed on 5/12,
We
my
will
lord.
say as a last opportunity, 2 weeks.
But since 2022, they have been taking time.
As a last opportunity, 2 weeks are granted to the counsel for the appellant to file the paper books.
Please.
Okay? Paper books in the registry and also in paper books. By giving a copy of the same to the counsel appearing for the respondent. Adjourn 2.
17-3. Please, ma'am.
Please, wait.
32 urgent. 33. Srimati Vanita.
Respond.
Pass over.
Not submission mode. Short accommodation or will have to next today.
This order is passed. Violation of private work. Who is for the petitioner?
Srimati Vanita.
For the rest.
What is the challenge? What was the challenge?
Let's challenge before the Son Court by the appellant. That is a CAT order.
What was the challenge before the
As-
tribunal?
Yes, my lord. As per UPSC report, the respond number 2 has passed order to impose a penalty withholding 20% of the pension
And gratuity.
and gratuity.
So what is the
That
difficulty?
the Honorable Appellate Tribunal is set aside that order of that is 20% of the gratuity set aside partly allowed by the Honorable.
Why the gratuity cannot be forfeited?
My lord, without following the procedure, my lord.
No, but gratuity includes, pension includes gratuity. Pension includes gratuity. Pension 20% uphold has been forfeited. Has been withheld, na 20%. Why not gratuity?
Page number 162, my lord. Eighth line. Man. We quash the direct the respond to release the gratuity forthwith and in any case within 1 month from the date of.
What is the reasoning given that gratuity? The other withholding is, it appears the word gratuity is taken to mean as it is dependent on whims and fancies of the employer alone. Unless it has been shown that the loss has occurred to the government, it cannot be established. How can he bring in this? See, he is a central government employee. And just give CCS pension rules. To comment about.
The paper book, page number 161, it is not all. Please, bro.
We want to understand. Whims and fancies is not the way. He should say the rule doesn't permit withholding of gratuity. Where does he refer to the rule? We will show you what is the rule.
We'll have it next week. I'll make us, please. Please.
7-4,
Please.
34, Shri T.C. Gupta. Serial number 34,
Looks I appear for the respondent counsel. May request for some time, my lords. He's held up in the other court minutes.
sir.
Looks I think he's online, my lords.
Sir, 34, serial number 34.
I'm told that there are other two matters also, my lords. Could it be tagged and posted along with those matters?
Seven four.
Much.
Serial number 35, Shri Muralidhar Peshwa. 35.
Lordship, the arguing counsel is not keeping well. Can I have it by tomorrow, your lordship? Tomorrow, yes. Much obliged.
4-3. 36. Shri Ajit.
Respondents.
Yes.
Lords, here, my lords, the petitioner applicant, my lords, is challenging the grading, my lords, of the year 1982 onwards, my lords, after nearly 3 decades.
Shri Ajit PB.
No, my lords. That relevant point of time, my lords, there was no provision to provide the ACRs. Please, my lords. And it is a delay, my lords, of more than 3 decades. Now she has also retired. Please, my lords. When it was filed itself, Mr. PB Ajit, my lords. Please, my lords. Please.
37 Arjan. 38, Shri Mohan Rao.
Suffering from throat infection. I am unable to speak, my lord. 17th or 18th next after 2 weeks, my lord.
Adjourn to, just have it next week.
Next week, 10th.
Next week, just give it next week.
10-3. Serial number 39. Shri Mohan Rao.
Same, ma'am, same.
10-3.
10th.
40.
For appellate marriage.
40.
I do it today itself only, my lordship. The amendment cast, I do it today itself, my lordship. Non-filing of amendment, I do it, my lordship.
Don't do it so long.
No, today itself, ready, my lordship. I do it.
The counsel for the appellant states that the amended memo of party shall be filed during the course of the day. Just give it, ma'am. Because it will end.
28-4. Passed over matters. Serial number 2, Shri Partha Sarathi.
Here for the respondent number 2. This petitioner has filed an application for recalling dismissal for non-prosecution. Leonard Singles. Leonard also.
First we have to recall.
Twenty-four-3.
Great.
Serial number 10. Serial number 11. Serial number 11, Sri Zamir Patel.
Appearing for respondent. Can you pass on? Pass on.
Seventeen. Serial number 20. GS Prasanna Kumar. 22. Kashyap Naik.
Lords, may I only request now to see the operative portion of the order. I understand what my lords are saying. It is only for the effect of this order because the order is directing me to deposit a sum of rupees 17 point something crores. It is without any timeline. It extends beyond the arbitration as well. Now, if my lords are to give me liberty to approach the tribunal also, the tribunal will not be able to say that the section 9 order is incorrect. I will have to ask for a reverse order before the tribunal saying, pass an order saying I do not have to deposit any amount. But I will still have to ask for a negative order in the sense that I do declare, I'll have to file a section 17 application saying, please.
We don't know, but section 17 court will decide, the arbitrator will decide it. Any modification, vacation, you will do it. We will not have to proceed. Let's be very clear and minded. Once arbitrator is placed, 9 is not maintainable.
That is exactly my ground of appeal, my lord.
So why are you here then?
This order was passed after the tribunal was constituted.
Then you have argued that? Did
No,
you
my lord,
argue?
it was not. Because it was, nobody brought it to the knowledge of the court.
That's the reason the first court we should, the very thing we ask is arbitrator is in place.
In fact, arbitration notice was issued 1 week after they got an ex parte order. Response was issued immediately. They took a year to confirm the name of the arbitrator. Their arbitration notice simply said, we want to go for arbitration.
It is your friend. Call him, pass over.
He's online.
The 22, serial number 22.
Pass over.
25. Serial number 25, Shajit.
May be permitted to represent on behalf of the appellant.
Yes. Now what is remains in this?
Lord, only submission is, my lord. The claim of the appellant is it's an Inam land and he filed a application under certain provisions, my lord, and it was rejected. There is no proper application and the proof of Inam is not forthcoming. In fact, my lord, he had certain documents to produce and time was sought, my lord, for production of those
But
documents.
these proceedings were had arisen from the
Tahsildar.
district court, district judge.
Appeal lies to the district judge.
You went there, you went there.
Went there.
What does he say?
That has not been proved. The claim is not proved.
That as Inam land also.
Yes.
So
Lord,
now that's the finding of fact.
Yes.
And that's what the learner single judge says.
But only one request, my lord, is.
What?
Lord, certain time limit was granted to file fresh applications. Lord, he has made a fresh application before the Tahsildar. Because one of the contention is there was no proper application that was made. Lord, para 5 of the impugned order, my lord, at internal page 5, ink page 21.
What does it say?
Lord, in the second line, it was further submitted that in view of the recent amendment extending time for filing application for regrant, petitioner had filed application and therefore sought for issuing a direction to consider by allowing the writ petition. I only humble submission, Lord, if a liberty is granted to pursue that application in accordance with law, he
But
can
how,
place.
tell us one thing,
Yes,
will this not be a res judicata in view of this?
Lord, here the contentions are different. Lord, where
This issue is same?
issue is same.
Then you may have 10 grounds, but then later realize, oh, there is 5 more grounds, I will file fresh petition.
Andre, Lord, certain certified copies of the documents.
See, we will not. See, it's a public policy.
Yes.
There has to be an end to a litigation, not back and forth, then go back. Not purpose.
Those documents you could not produce earlier, which shows that it is an Inam land. Lord, it's a certified copy is issued
And
by the
mind it,
authorities.
we are, first authority is Tehsildar, district judge, single judge, and we are. Both 3 authorities,
Yes.
you could not establish your case. And in the appellate jurisdiction, and the learned single judge was also right,
Yes.
all findings of facts. Just see para 11.
Yes.
Admittedly, petitioner's claim is based on entries in Khetwar register.
And other etc. It's put as etc. There are certain
While
documents.
passing impugned order, learners is consider relevancy of the entries in this as well as other records produced by petitioner and specific finding is recorded as said testimony would themselves would not indicate that the lands in question were not in arms. Now you may be producing the same documents of which a reference is made here.
No, there are other documents therein.
Mind it further.
It is
Read it further.
Further.
Said conclusion of whatever referring to conduct petitioner father who had filed application obtained re-grant in respect of Inam land,
Other
but
Inam.
maintained silence in respect of these lands. Moreover, claim for declaration of title and mind it appears that for other Inam lands you made a claim. You succeeded.
Yes, yes.
Yes.
But for this you did not.
Yes. My father had filed application.
That's right.
Yes.
You are now seeking. Your right is only accruing
Based
through him
upon
only.
Yes.
Claim for declared title, legatee, bill, this, not as Inamdar, would also indicate the said lands were not in. Moreover, claim for declaration of title as legatee under will dated 10/7/1922, he knows this, I don't know why I said 22. And not as Inamdar would also indicate the said lands were not Inam lands. This is something which is being, your own conduct is being taken against you.
And a suit was filed in respect of 2 other items, challenging on the question of will, etc. Lord, as far as Inam lands are concerned.
You did not make any claim.
No, this was also part of the suit minutes. Totally 4 suit schedule properties were there.
That was
These
deleted
2
later.
properties were among those 4.
That was deleted later.
These 2 properties were part of that suit.
Yes, ma'am.
Initially, it was a part of that suit. It was included by oversight. Later, he has deleted those 2 items.
In fact, the district court has looked into these aspects, my lord, at page 59, para 25. And additional documents also were produced, which is also taken note of by the district judge at para 13, page 49. Para 25, the appellant has failed to show that the disputed properties are.
Which para are you reading?
Para 25, my lord, of the district court order
Page.
at page
It should be 59.
59.
59. Ink page 59.
Internal.
Yes, read it.
Therefore, the appellant has failed to show that the disputed properties are Inam lands attached to the village office. In fact, the appellant has taken dual stand
Before the Tahsildar, this court, he asserts that the disputed properties are Inam lands. However, in his suit, OS so-and-so, he sets up his title to the same properties under a will. As such, a dual stand taken by the appellant are destructive of each other. That makes it clear that the appellant is not specific about the nature of the disputed properties. And at this, during this time, my lord, at para 13, at internal page 48, he has also produced certain documents, establish his case. That also has been taken into consideration. Before arriving at the fact that regrant cannot be permitted.
Para 19 is also relevant, madam. If you could see.
And these are, we are concerned with survey 63 and 82.
Yes, yes.
82.
Yes.
Village were not included. There is no explanation by the appellant why those two properties were not included. See paragraph 19.
Yes, madam.
You have seen that?
Yes.
Yes.
See, after this, to say that now I want to revive is not permissible. It's like, you know, rectifying or mending what you have not, or you have failed to do or erroneously not done.
But in fact, those two items in the suit have been deleted, the district
How
judge.
do we get that? This is the noted by the district judge.
Yes, it was deleted.
How do we get that? And very well, deleted.
Yes.
But even your parents, your father had filed earlier suits.
Father had filed, no, not so.
This para 19
Lord, he filed application for regrants. These two survey numbers were not
are
included.
not included.
Not included is the.
That's a very important factor.
Yeah.
I didn't include it. What you want to do is same two lands, you are now seeking as an Inam land,
Yes,
which you did not, your father did not do it.
he omitted to claim.
Omitted or whatever. It's as good as you have
Not claim.
accepted. Those are not Inam lands also. That's the consequence.
Yes.
So, and see the learner single judge. Para. Yes. These moreover, the claim of declaration based on, or you say, so how do we say you have deleted these two lands from the suit?
It was by way of an amendment, my lord, it was done. I have not annexed it along with the writ appeal.
Establishing that. And even if you have deleted, you can't,
That's so.
you can't overcome what your father has not included.
Yes, yes.
That's right.
That's right.
So back in the year 1972 itself, my lords, his father has filed an application seeking for regrant of various other lands, excluding.
Not excluding.
No, we don't apply
Just
for
say
this.
this,
It goes to show that those lands were not Inam lands.
It's all right. What is a good name? Your
V.
counsel?
K. Bhatt.
Mr. V.
Okay, Vijay Krishna Bhatt.
Just Mr. We have heard Mr. Vijay Krishna Bhatt for the appellant.
Hemant Kumar D. Minutes for
For?
respond number 8.
Respondent number 8 is so and so. Madam, you will appear for?
1 to 4, my lord.
Who appears for this 5, 6, 7? How are they concerned with this?
My lords, from them I have purchased minutes. They were earlier ones. Yes.
Did they appear before the learner single judge? Sure. What is PH means?
PH are referred to what?
Just say, but they have been served, no?
They are
No.
represented.
Yes, yes.
Huh?
They were served before the learner single judge.
But here notice not has been issued.
Not yet been issued.
Acha, the
But in
challenge
fact,
is-
now R7 has died about a month back.
No, but say that respondent number 8, the caveator.
Yes, minutes.
You're the caveator.
I'm the caveat.
You are the contesting party.
I'm the contesting party. I'm the owner of the property.
The contesting caveator oblique the contesting party. The challenge in this appeal is primarily to an order dated 16 June 23, passed in writ petition 14136 of 2018, whereby the learned single judge has dismissed the writ petition filed by the appellant herein by stating in paragraph 11 and 12 as under. The submission of learner counsel, Mr. Bhatt, learner counsel for the appellant, is that the suit of which a reference has been made by the learner single judge in paragraph 11, comma, being OS 1343/2008, comma, the two lands which are the subject matter of which were the subject matter of the writ petition were deleted. And hence, the conclusion drawn by the learned single judge in that regard is not tenable. Full stop. But he do concede the observation, the conclusion drawn by the learned single judge that the father and the uncle of the appellants had filed application for grant of Inam lands. Inam lands, but did not include the lands of the petition lands, the petition lands being survey numbers in survey number 63 and 82. Survey number 63 and 82. As is clear, as is clear from page 53 of the paper book, more particularly paragraph 19, wherein the following has been stated by the learned one additional district judge in his order dated 7/3
7/3/2018.
7/3/2018 in MA 39 of 2007. Which order was challenged before the learned single judge. So Mr. Bhatt do concede to the fact that the said lands were not, the petition lands were not part of the claim made for grant of Inam lands, no?
Yes,
By the father and his two brothers.
as it was omitted to claim. As they were omitted to claim it.
Were not
Yes.
included. If that be so, comma, the conclusion drawn by the learned, the final conclusion drawn by the learned single judge in the impugned order, more particularly that the learned district judge has arrived at a finding of fact, and also the fact that the conclusion drawn, and it is also not the case of the appellant as contended, as argued through Mr. Bhatt, that the conclusion arrived at is contrary to material on record, comma, the impugned order cannot be interfered with. We do not see any merit in the appeal. The same is dismissed.
One request, Lord, I may be pardoned, but my request to consider the fresh application.
See, this is what will be.
One line of observation.
We say nothing on that. The finding of fact which has come, we don't know. We don't know.
That may be turned down.
Pardon?
That request. A request has been made.
See, this has been dealt by the
Yes.
learner single judge. See, tell us one thing.
Yes, Lord.
Why should we allow it? Let's now legally test this argument.
Yes.
Why should we allow it? No, what is going to happen? It's just a huge precedent, not only in this case.
Yes.
Now I got fresh documents. Now I did not raise these grounds in the earlier petition. Allow me. This would be endless.
Endless.
There would not be any, finality to a litigation.
So my request is to record that submission and it's not sustainable.
You have made it.
Yes,
Just say that at this stage, learner counsel for the appellant would submit. What do you say? What is the submission?
that fresh application making claim under Inam's Abolition Act has been made. The
Then-
liberty to pursue that application may be
That
granted.
at this stage, learner counsel for the appellant would submit that as a fresh application has been made, liberty be granted to the appellant to pursue before the Tehsildar, before the Tehsildar, and liberty be granted to pursue the same. We find that the learner single judge had noted the similar submission in paragraph 5 of the impugned order. And despite such submission, the learner single judge has not granted the liberty and dismissed the writ petition.
Yes.
We also do the same thing.
I'm sorry, my lord.
Shall I tell you, Mr. Bhatt?
Yes.
We appreciate that. You have done your duty. Right. We have done our duty. Thank you. Respects.
Serial number 28.
Yes, ma'am.
Before I proceed with the Prabhakar's judgment, there's one another factor. In the annexure A, my lord, the reference order itself is erroneous. On that ground, the learned single judge has dismissed has allowed my writ petition. Kindly see annexure A, my lord.
What is erroneous in the reference order?
My lord, the order of punishment was never questioned. The order of punishment, the order of implementation, my lord, order is under
Let's see that.
annexure A, my lord, page 20, is the order of punishment. I'll just read 4 lines, my lord, from the order.
Which page?
My lord, in my paper book, it says page 20. My lord, if your lordship, the competent authority has ordered to reduce the pay by lower incremental stage without cumulative effect for a period of 6 months, wide order dated 31/191 in respect of KVS Shetty attached to so-and-so, accordingly pay fixed as follows. During the period, he will not earn increments and this reduction so-and-so, so-and-so. Well, this order is only an implementation order by the accounts department, my lord. The actual punishment order is 31/191, my lord. Now your lordship may kindly see the order of reference. That is in annexure B, my lord. It says, my lord, whether the management of management of KSRTC was justified in reducing the basic pay of the reducing one annual increment for a period of 6 months, wide order dated 7/3/1990. Even this order is not 7/3/1990, the annexure A, my lord. It is 7/3/1991. Now your lordship may kindly see the labor court, my lord, interprets and says it should be read as 7/3/91. Says it's a typographical error. Kindly come to page 48, my lord. In page 48, paragraph 3C of the award of the labor court. In the bracket, my lord, though in the order of reference, the punishment order is mentioned as 7/3/1990. It must be a typographical error. It should be treated as 7/3/91 as per the punishment order produced by the first party as per Exhibit W1. Exhibit W1 is annexure A, my lord. It's neither 7/3/90 nor, my lord, 7/3/91. The order of punishment is 31/7/91. That should have been produced, my lord, before the conciliation officer and sought for reference of the order of punishment. On that sole ground, my lord, the reference order is quashed and the order award of the labor court, my lord, has been set aside. My lord, so happened, my lord, much after his retirement, this was questioned. Even the orders of punishments were not retained, my lord, in the corporation except his service register. Now the order of the learned single judge, para 6, my lord. My lord, what was submitted to the learned single judge was, when the order of punishment itself is 31,191, my lord. The annexure A cannot be read as 7390, my lord. It is corrected and on the top it is written as 91, my lord.
Yes, Mr. Rao, what do you say?
No, Lordship may kindly see Annex A. It is, here is mentioned, Divisional Establishment Order number 1295 of 1990. There is 31,191 is there. Therefore, Lordship may kindly see, they did not, government order has not challenged. Soon after receiving the copy of the government order reference, the duty of the management to raise before the writ petition before the Honorable High Court of Karnataka. This is not good. The reference is bad in law. Therefore, raise a dispute, file a writ petition challenging that reference. It is there is the Supreme Court says one. I did bring
How much is the amount effect, financial effect?
Effect is only till 20,000 or 10,000 because the whole period will be goes up to 2004. One increment 6 months. It will be calculated 15,000.
From 50 to 30, you reduce by 30 rupees.
Yes.
80 to 50.
And not only one, my lord, he challenges 8 orders together.
That
After
different.
much after 8 years after his retirement, 8 years after the superannuation, my lord, he challenges all the orders, my lord, which are passed during this period. And all the 8 writ petitions have been allowed, my lord. My lord, on delay, my lord, I had taken pass over, my lord. May I pass on this, my lord, on delay, my lord? Ready, permitted to give the superannuation date, my lord, 31/7/2004, my lord. 31/7/2004 is the date of superannuation. Award is, the reference is in 11, my lord.
No, not 11.
After 6
Lordship,
years.
this is not, it is unfair.
Annexure B, I have produced. reference
Lordship may
order.
kindly see the award copy, read the award. They take, I have taken, the court has taken 2005 soon after rise, again refer the matter 2011, the second round litigation. Because you did not file a single reference, therefore reject the reference on that ground. And they was again filed a reference before the conciliation officer. The award is clear.
Para 27.
Lordship,
Para
Lordship,
27, my lord, is.
Lordship, may kindly see the award to page 64. I read once again award. This is thoroughly I read award. Page 64, Annex F.
Raghubir Singh's case has been referred to in para 27, my lord. And after that, my lord, the apex court, my lord, comes to the conclusion that at paragraph number 29, my lord, goes into the aspect of the delay, my lord. And at the reasoning starts from para 37 onwards, my lord. Especially 38, my lord.
Page 64,
Maximum of.
page 67 award.
Yes, sir. Judgment noted. My lord, para 37 and 38, my lord. Let us examine the matter from another aspect, that is latches and delays and acquiescence. It's now a well-recognized principle of jurisprudence that a right not exercised for a long time is non-existent, even when there is no limitation period prescribed by any statute relating to certain proceedings. In such cases, courts have coined the doctrine of latches and delays, as well as doctrine of acquiescence, and non-suited the litigants who approach the court belatedly without any justifiable explanation for bringing the action after unreasonable delay. Doctrine of latches is in fact an application of maxim of equity. Delay defeats equities. Then, my lord, para 42, my lord. On the basis of the aforesaid discussion, we summarize the legal position.
Come to
as-
42.3.
Yes, my lord. 42.3 is the relevant, my lord, for the present case. And my lord,
Yes,
40
Mr. Rao, you are seeing.
Yes, Lordship, may kindly see.
uh,
Page 67, para award in the award. Para 3C, it is further stated that, I read my permit, that the first party earlier raised an industrial dispute challenging 9 different punishment orders, which came to be
no,
registered.
no, forget, that's not the issue.
That's not the issue, sir. I don't know what I submit, because when 2005 I raised,
Yes.
the
Issue is
court,
1990 order,
correct,
you raise in 2005.
correct.
What do you have to say? That is what being dealt by the Supreme Court in this paragraph. Read
Now,
it.
earlier Raghubir case.
You are not precluded as long as you explain the delay. Where is the delay explained?
No, delay. I filed a soon after receiving the punishment order of disciplinary authority, I filed a
What is the appeal?
appeal.
Show us the appeal.
I taken that contention, they did not file any, I read the award.
We should see, let's see, what do you say in your appeal? Where is the appeal?
Appeal is not mentioned here. I did not exhibit, I have exhibit, but they did not disclose.
Have you exhibited?
Yes, they exhibited
How do
earlier
you-
order. 2000 in the 2005, 1994, 2005 order, I will exhibit it.
How do-
All the appeal.
See the award. Ma'am, which page is that award?
Lordship may kindly
See
see.
the documents which have been exhibited.
Not in this case, I exhibited disclosures.
Page
Lordship-
81, 81.
Lordship kindly see.
Mr. Rao, there has to be. There should be something on record to show that you filed in this. Now come to page 18, 81.
81 is only 2 documents marked.
Then we read, which is the third document?
Third document is not disclosed here.
Who has not disclosed?
That labor court has not
Oh,
shown that.
Labor Court did not disclose. What is this, Mr. Rao?
No, I,
1 minute. You will listen
Not-
to us. 1 minute. If Mr. Rao had filed it, the Labor Court would have shown it. Simple. That's right.
right. What had happens, definitely I will file.
There may
All
be
the
a-
cases I will file.
There may be an error. We are not saying anything.
No. I'm not to say, sir, I'm genuinely and fairly I have submit. Before
So-
this court is very good court.
So to
Then let the court will be, connect all the matters. I will show that all the exhibits.
How many matters are there?
There are 9. Here is the para I read.
All different punishment orders.
It is further stated that the
They're all
first party
different punishment
earlier
orders.
raised an
Ask
industrial
different-
dispute challenging 9 different orders. Here is the para 3C in the award.
We are only concerned with
Yes.
this appeal. We are concerned with this appeal only.
Yes, sir.
In this appeal, the learned single judge has set aside
Yes.
saying that the reference sought was belated.
Only that.
That's right.
Yes.
It's belated.
Oh.
So belated, you have to only answer the conclusion drawn by the learned single judge that a 1990 cause of action could not have been raised in 2005.
No, the employer was soon after receiving the government order, they did not challenge before the in the High Court challenging that reference order. That is the Supreme Court says.
What did they challenge?
Reference is not challenge.
What did they challenge?
Punishment order.
Not punishment, award.
Award.
Award. Now come to the award. The award also includes a finding that there is no, the limitation is condoned. Right?
Right.
Right?
Right.
Tell us what is the justification given by the labor court to condone that when you did not explain the delay? Did you explain the delay?
Yes, Lordship, I have WW1 examined before the labor court and those documents marked and I will file affidavit exam in chief. They did not raise.
Kindly see page 61, my lord. The documents produced by him, there is a reference at page 61.
Yes. So you only produced 2 documents. You did not produce the 3rd document. You did not produce the appeal. You can't say that you were waiting for a reply on the appeal when you did not submit. Okay. Now, what is the cross-examination? Which page is your cross-examination? 64, 62. Let's see 62. How is this cross-examination relevant to explain delay? How is it relevant?
Because of one document, that's exactly
We are asking you, you
Correct.
are relying upon this cross-examination,
of the MW1.
MW1.
Yes.
How is this cross-examination relevant for the explaining the delay?
It is their evidence. Lordship may kindly see, it is their evidence, it is not my evidence. In their evidence, cross-examination, I'm thoroughly, page 53, 54, 55. Para 4, like page 53, 54, para 4, read. May I read that the destroying file is made entry in the register. It is not true to suggest that I have not searched the file in the record section. And I am deposing falsely that the file is not traceable. It is not true to suggest that after retirement of the first party workman, the service register and the personal file of the first party workman is still available in the establishment section. I know the General Standing Order 250 dated 8/6/78 is amended. The said circular was got amended in the year 2009. It may be true that the circular number 250 might have been amended in the year 2011. It is not true to suggest that the service register personal file. Yes. No, because of they did not file any document, personal file, available all the records. The duty of the management witness is to bring all the records till the retirement, they have preserved the records.
Why did you raise it in 2005? Is something which they did not produce. But why did you raise a claim in 2005? When the order was passed in 1920? That's the issue.
Correct. That because of the reason is Lordship, why I have not filed? Soon after, immediately they asking that. Simple. Yes.
He can only say, I could not find Mr. Rao. I was waiting for him. After retirement.
Because before raising the dispute, they have give major punishment because I am working till in service. That is the point. Punishment. Yeah, facts. Right.
There is not much financial effect.
Effect.
That's a valid argument you can take.
Yes.
But the only thing is you have a more of a principle.
Correct. Okay.
My lords, this permission, if I may make a mention. My lord, serial number 17, my lords had passed over this matter. This was an appeal from an order dismissing a section 9 petition. We had submitted that the arbitrator is appointed. Client has, we sought instructions, my lords. This appeal may be disposed, permitting us to urge all grounds before the arbitrator without the order of the trial court coming in the way. Order of the trial court coming in the way. I will withdraw it. My lords, my only difficulty of one submission on merits is presuming that the arbitrator were to also, apologies, arbitrator were also to dismiss my application. It should not be that there are concurrent findings against me.
There is an order against you.
Yes, ma'am. Yes, ma'am. Please, ma'am.
Variation of that.
Or fresh relief, same relief as sought for the trial court. Yes. I was the petitioner before the trial court as well. That was dismissed, my lords.
Such application as deemed appropriate for such relief
Please, my lords.
Please.
will be decided without being influenced by the order passed under section.
Please, I'll be grateful.
Please.
May look at my learned friend's consent as well.
The number.
17, sir.
Yes. I filed my card today.
Harsh Gupta.
Vinod. Yes. Yes, ma'am.
By this court.
By this court, my lord. The CMP.
CMP. It can be.
Petition, appellant here.
And the seized of the dispute. First off, the say that we saw, that we saw, and also agreed by the counsel for the respondent that liberty be granted to the appellant to file such application as deemed appropriate for the consideration of the learned arbitrator for the decision. Right? This submission, this is the therefore said is agreeable to the learned court for the appellant which states we shall withdraw the appeal and file appropriate applications as deemed appropriate. And for the consideration of the learned arbitrator, we only state that any on the application, either learned arbitrator shall be without being influenced by the impugned order which has been challenged, impugned order dated so which has been challenged in this appeal. So this submission of the counsel for the appellant is agreeable to Mr. Vinod appearing for the response.
Please.
We accordingly dismiss the present appeal as withdrawn. As withdrawn with liberty to the appellant to file appropriate for consideration of the arbitrator.
My lords, if I may make a request, my learned friend has filed an NOC wakalat today. Let that be just taken on record and be recorded in the order, my lords.
See,
From another counsel, my lords. So let that reflect in the order. Praveen Gowda. Mr.
H.C. Praveen Gowda. Yes. Yes, my lord. Today I filed in before the registry. I'm there on record even the arbitration. So I'm there on record even the arbitration. No, my lord.
They-
Yes, acknowledgement they give, my lord. Today afternoon, my lord.
I'm grateful.
Similar matter, similar situation, serial number 20, my lord. I got the instruction that it's been filed with file number 588 of 2024. It has been filed. The proceedings are pending before the arbitrator has been appointed. In this notice was not issued at, we had come on the first time this hearing, and there were two matters section against me. They had preferred the application before. It was in there, injunction was ordered under section 9. Challenging the same before this. There are two applications they had filed. Common judgment has been passed. Challenging that, please, grateful. And also maybe tagged along with another appeal arises out of the same common judgment. Please, my lord, I'll file a memo. Same year, 2024, my lord.
Twenty.
20.
20. 20, sir, 20.
Date for
21/4 dates. Serial number 29.
Inform the respondent I will be requesting for a response. Just say but the respondent is requested for 12/3, I leave it to the court. I want it day after tomorrow, responding said, see if 12th is possible.
5/3. Serial number 22.
I appear for the.
We'll have it day after tomorrow.
Grateful, my lord. May I request for the council to send me a copy, my lord,
Just give him a copy.
of the
Just between both of you,
grateful. Grateful, my lord.
which is the next one.
29.
I tried to contact the council for the petitioner. I could not get him. I sent a message also.
Is it a date given matter?
Twelve three. Sir. 36.
FD for the response. It's Mr. PB Ajit, my lords.
36.
No, my lords. Last time also they had taken time. Lords, the petitioner applicant is, my lords, challenging the annexure A7, my lords, where her representation, my lords, to challenge to the ACRs, my lords, of the year 1983, 84, 85, 86, my lords, were disposed of. Devdutt's case, my lords. Earlier, my lords, they never used to communicate any ACRs, my lords. This pertains to the year 1983 to 87.
Seventeen-three.
Much.
Serial number 9.
Hearing for the respondent, my lord. The matter was already partly heard, my lord. The petitioner was granted first ACP. And later he was given MACP also. And the petitioner is asking for having the ACP part retrospectively, which is not possible with the MACP and the 6 pay commission reports.
Eighteen-three, madam. 18-3. Serial number 11. 11.
We are for a proxy counsel for the, not the appellant.
Okay,
The appellant counsel is unwell, it seems, requested for mention for 2 weeks accommodation, Lord, to file a paper book. Two weeks after, Lord, any date, Your Lordship.
Eighteen three.
Oblige.
Much obliged.